Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out. We got this far, don't know how. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we're gonna let it away. Tonight, we're gonna let it away. Tonight, we're gonna let it away. Just like the sunrise, we're gonna let it away. Just like a spark that's breaking out. Can't make a stop, can't turn back now. We know that there's no room for doubt. No, we can't turn back now. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we're gonna let it away. Tonight, we're gonna let it away. Tonight, we're gonna let it away. Just like the sunrise, we're gonna let it away.
Hey everybody, welcome in, welcome in. Let me know if you guys can hear me okay. I think you guys can. I'm using my wireless mic today, so that way I can move around and not be in one spot. So I'm gonna go ahead and I'm gonna put it right on the court proceedings because they did start already, but thank you guys for being here. I appreciate it. They're just starting, so we're not missing too much right now. But hello, Ladybug. Thank you for being here. Pretend Judge, thank you for being here. Petunia, Nicole, welcome in. Hey, Squeaky, welcome on in. I'm going to be getting it right on there. Hey, Nicole. I think I already said Nicole. Maybe not. Hey, Willows. Welcome in, everybody. It's good to see you guys. Hey, Catherine. Hey, Kelly. We will get right on to it. I just wanted to say hi to you guys. Hey, Kiwi Mate. Welcome in, everybody. Okay, great. Thank you for letting me know. I've never used these before, and they're really cool. So I'm pretty excited. I'm going to start using them for the pre-recorded. So I wanted to give it a try, but I paused it so we can go ahead and we'll start it now, and it'll probably have to refresh.
There will be a timely objection, and the court can address it in that fashion. So our prayer to the
There we go. And look at old Bryan in his blue shirt, no tie. Good choice, and good
court
choice.
is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms or their equivalents.
Which ones?
If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't, obviously the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. And certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. This, I would imagine from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say, don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, the state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court prefers.
Let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit it to the court.
I think it's the defendant's
on the
motion, so if they want to argue it, they can.
Honor, it's the state's motion.
Oh, is it the state's
It is the
motion?
state's
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. This, if you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger or something of that nature, as I
Yes,
understand.
Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments, that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And defendant replied basically saying the same in their response, that they suggest he use phrases that comport with existing language and statute and jury instructions. And that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan. And so the state has expressed that they plan
That's
to use
how you
that
can use
paper.
it. It's
I'm sorry, I can't
that's
hear you.
how that's how you can use it under 404. The way you can't use it is a prior term of colloquial term is a prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in run. The same example that I will give you has to do with
Help me
the
understand your-
Amazon records.
I don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is in essence trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
It's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice, they should not be able to argue evidence is a prior bad act or make any attempt at an in run on that rule.
So I'm not understanding what you mean by an in run on that rule in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th,
Right.
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
You don't know what they're going to do.
I think I understand what you're saying. I just think we're
So I think,
completely missing
okay.
each other's understanding of the rules of evidence.
Well, I still stand by my position that the state should not be able to in run that. And I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or
On
keep it
the, on the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car. That is not just the make and model. It is Mr. Kohberger's statement that he doesn't think state seatbelts provide much in the way of safety. Mr. Kohberger's
Oh my
question
gosh.
about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So
Of
it's
what year?
of 2022. So it's remote. It's
Before the murders.
yes, before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's
I mean,
different.
the point of it being, as I understand it, is to show that the defendant owned a white, well, I can't remember the name, the maker.
Hyundai Elantra.
Hyundai Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state has, the state is.
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera. To me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but.
Okay, well, they've noticed it as 404B evidence. So I'm
traffic stop.
arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
But you don't get
his
to, and
phone
I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern?
Look at the judge.
The video, as I understand it, first you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so, can you address that part of it, the prior bad act, and how the court should deal with that? And then also, I am concerned with the issue raised about the communication between the officer and Mr. Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. And I think when you review the video, you can put it, the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different as being prejudicial. We certainly are not trying to argue some sort of propensity that because he question about, why do I need to give you my driver's license? That all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case. And so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so, I don't think we can say that the shot clock has run out on that at this point. But certainly, as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related, well, let me go through the 404B analysis. It is technically another a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case, there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile, and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not substantial. I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404 or notwithstanding 404B and 403. I do want the video potentially, I'll look at it and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer about that was mentioned that, you know, that Mr. Kohberger questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does potentially create some unfair, some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that he, his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family in general, in terms of a reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged. The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held, the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, so it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber. And for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support Mr.
The reason
Kohberger.
you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them, and picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute and gives bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says that court can't use the exclusionary rule where in good faith a person who's otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against them with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you. I'm going to take this matter under advisement. The defense raised some cases. I want to read those, though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that, I can only imagine the family of Mr. Kohberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course. All right, let's talk about the defendant's motion regarding conditions as an aggravator, and this is the concern about using the defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is. We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes Bryan will talk longer than maybe other people want to listen, and that doesn't mean anything.
I assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Kohberger, and that's what we don't want. We want to be able to present, if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has, and to prevent the state.
Reading the the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with how we deal with that with the jury in terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that?
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Bryan against him, to say that he does things that are consistent with autism and that that's an aggravating circumstance. That's
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
Well, I would hope that it wouldn't be presented that way. But Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And a lot of their unkind things, when you understand them in the context of autism, the way he
What? What happened? Their stream went down. Oh, there we go.
that's using his autism characteristics.
How do I though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to in a mitigation aggravation penalty phase. Your position is that's due to his spectrum disorder, whereas the state's view may no, that's not. That's his view of women and goes to motive, etc., and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his.
Do they even
dislike
use the word
and how he
Asperger's
responds.
anymore?
That's exactly the problem, Your Honor. If the state, and
Do you want
I-
me to,
I
you
wanna
want
be
me to weigh in and
clear.
say what the factual findings are, that it's this and not that? And I'm not sure I can do that short from a jury instruction that, you cannot use mental health conditions as an aggravating factor.
that's an appropriate jury instruction, and if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present
There
mitigation,
may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to, if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
Response?
We understand that the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. You know, the state certainly shouldn't make those arguments, and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor. All right. Why don't we take the morning break? We'll take 10 minutes and be back at about 20 till.
Okay, sorry about that. I was cleaning. I'm in the process of like cleaning everything, so it's kind of a mess over here. But so basically, this is the morning break, and they are so far. Anne is not doing very good. Let me move this real quick so I can get in front of the computer. There we go. So Anne can't use the no one can or not Anne. I'm sorry. The prosecution can't use the word sociopath or psychopath. The judge was talking about the autism spectrum disorder. It seems like he doesn't really want that to come into play either at trial because it's just new information. It's coming out of nowhere. This stuff's coming out of nowhere. They still have a lot to go over though. They have like the bushy eyebrows. Trying to think what else was on their list of things to do today. Actually, you know what I'm going to do? I'm going to go over to X and see if Brian Enton, News Daddy, if he's oh, sorry, I'm trying to put my desk down. See if he's tweeting anything. I should have had this up because he's usually on it. Let's see if he's saying anything. It just says the Idaho courts are no longer using the YouTube page. I already put that. It just says judge will consider what evidence is allowed at trial and all the motions both sides have made. And there's so many motions because we haven't been in court since the end of January. And he wanted to make it where they were going to court once a month. Let me share this with you. Look at this. Oh, oops. It says Bryan Kohberger's defense, trying to mop the ocean. It's pretty funny. It ain't going to work. It ain't going to work. Oh, yeah. The term Asperger's, yeah, it is outdated. I was surprised that they used that word. I know I used it the other day, and I was like, wait, that word isn't even really used anymore. But yeah, he can't, I mean, he has a level 1 autism. When I looked at it, that's like literally like a sprinkle. Like it, you know, like his DNA. That's about as big as it is. So I don't think they're going to be able to use that at trial. I don't see it anyway. Looks like JLR was, oh, he's just chit-chatting it up. Annette Levy said, interesting, Bryan Kohberger's lawyer, Elisa Massif, says despite the state saying it may call his family members as witnesses, his family has no interest in helping the state, and the only reason they don't attend the pretrial hearings in person is because they don't have the money to do so. Yeah, okay, I'm sorry, but you can make it out for one hearing. What about when he was going to plead, when he was like his arraignment, like when he was pleading guilty or not guilty? Maybe go to that court hearing. When they brought up the death penalty, maybe that would have been a good court hearing to go to. There have been some that, you know, you can go that they could have went to. When they say they have no money to go out for the court dates, I can understand that. Like you can't fly every single time. I mean, that would be expensive, but to not show up at all, that says a lot. You know, to me, it does. I mean, if that was my parents, I would be like, you better get on a plane right now and be out here. Like, save me, you know? And then the way she was like, Bryan Kohberger needs his parents here and this and that and the other. Well, I'm sure Steve Gonzalez has got a lot to say about that. I couldn't believe they even said that. I'm trying to think, trying to find where we're at. Where the heck did the page go? That's so crazy. Did I, oh, I don't know. We'll just do it right here. We'll just reopen it. It's still, they're going to be on a break for a minute. That was, I mean, he took a break pretty fast. It seems like he needed it. So yeah, they're on Zoom. Yeah. Yeah, Ashley, I believe that too. Not to not show up at all means they know he's guilty and don't want to get caught up in the crosshairs any more than they already have. Yeah. I think that I think that they're trying to keep it low key. Yeah, they can do a virtual appearance. Just show up for I mean, I don't know. I know that it's across the country and everything, but still, if you chose to send your kid or they chose to go cross country to school, then you guys should have the financial means to be able to fly out there and visit him or have him come home and visit you when there's like a break or something. But then all of a sudden his dad can drive or fly out to Washington, which is expensive, then drive all the way back and stay at a hotel. Like, why wouldn't you fly back? That's just stupid. Like, I mean, really, to drive back, that's so much more in gas, wear and tear on your car, hotel, lodging, food, all the things you need, gas. Hey, Felicia. Yeah, right? Yeah, exactly. My mom would have done the same thing. She would have walked there if she needed to. Thanks, Shells, for becoming a member. Thank you. Yeah, the not having money is BS. They're going to be witnesses. Yeah, they're going to be called as witnesses. I mean, his dad drove cross country with him right after the murders, a month after the murders, they're driving or less than that. They're driving cross country on, a road trip. Then you have a sister. One of the sisters said, "Hey, Bryan has that car. Bryan has bushy eyebrows. Bryan fits the description of the person that, committed these crimes." And then she went and told the whole family at dinner. So they may call his aunt and uncles. I mean, we don't know. We don't know who was all there for the family dinner. When she was like around Christmas time, I'm assuming it was a dinner that she said it at, but I don't know that for sure. I don't know. It's just crazy though. They are probably scared he would get off. Imagine the fear that he'll come back home. Yeah, VV. I wouldn't want him living near me. You think he wanted to get rid of the car? I think either he wanted to get rid of the car, like he was going to do something to where he had to get a new car, or he wanted to take his car. That way the cops couldn't go and look at it without him being there. Like if he did get caught up in it, or maybe he just wanted the extra time to clean it out. Yeah, there was an aunt, I believe, in Vegas. That might have been the aunt that she couldn't use her pots and pans because Bryan said that there was meat cooked in them before. Yeah, the house, yep. Mm-hmm. They have an expensive house. They live in an expensive area. The Poconos is nice. My mom used to go there to ski when she was a teenager. She told me that like a long time ago, but I know everything about my mother. And we're from Pennsylvania. We're from Philadelphia, but my mom was like all over the place. Like, they moved, or like my mom and dad, they were always traveling through the state. So let me go back over and see if they're back on. Okay, now the page is white. That's weird. Okay. Let's see. It just says the court is on break. He needed a break. He was like, I'm done. I'm over it right now. Hey, maybe Ashley. I never thought of that, but that could be the reason, really, for real. Like if he was on substances, he would have wanted to drive back instead of fly back. You know what I mean? When you're walking through the airport and them drug dogs are there, like, and you have to walk by them. I hate doing that. I don't have nothing on me, but I'm just always afraid they're going to like just, chase me down anyway. Yeah, they frown upon that, Ashley Higgins, don't they? But if you hide it good enough, I'm just kidding. I'm kidding. Your nephew was recently diagnosed level 1, and we were told to look up Asperger's syndrome to gain knowledge. Oh, understanding, even though the term is no longer used. Yeah, they diagnosed me. How long ago was that? It's been within the last year because the Sebastian Rogers case, we were covering it when my psychiatrist, they were diagnosing me with it. It makes sense. Like when we were talking about the symptoms, or I was like, oh wow, that makes a lot of sense. I wish that I would have been able to be diagnosed earlier in life. I think it would have helped me a little bit more, like with understanding and stuff. I don't know. I'm not like, I don't know. I think people with autism are extremely smart. I really do. I'm not saying I am. I'm just saying I think people that have autism are extremely smart. And people with autism are able to live a normal, happy life. All the only thing that, like with me, and I'm not saying I'm not, I mean, we're all different, everyone's different, but with me, structure is good. Like having a schedule that makes life so much easier, just to like getting stuff ready the night before, just planning ahead. That really helps with, having autism, I think. I need to work on, I don't know, like talking with people. I feel like I'm more reserved now. Right? Your whole life just makes sense. Yeah. You're like, oh wait, no wonders why I didn't like to do that. No wonders why I didn't want to do that or this or that. Or, I have sensory issues really bad. That's probably the worst out of anything. Like any of my symptoms is the sensory. I have to wear certain clothes. I have so many clothes that I can't even wear now, just because of the way they feel. And they're not hard, they're soft. Like if someone else were to touch them, they'd be like, oh, this is really soft. But when I touch it, like I can't stand it. Like something with lace on it, I couldn't probably do that. I don't know, there's just certain stuff I can't do. That's why I love Target, because they have clothes that are for sensory issues. So and it's perfect. I don't know why there's not more stores like that. The socks, yeah. I'm telling you, I'm gonna have to show you sometime. There's a pair of socks they have at Target, and it doesn't have the seam. It has a seam, but you can't feel it or see it really. It's really weird. And I was thinking of you when I put them on. Itchy jumpers, yeah. There's just some things I just can't. Yeah, routine is definitely very helpful. Oh, bamboo material. I have bamboo sticks in my house. Oh, like the baby clothes. Oh, I know what you're talking about. Yeah. Yeah, they're soft. I don't know. It's just something about it. I have to have something soft on. I'm a weirdo. Can't help myself. But hopefully Judge Hippler rules on everything. It looks like he's ruling on everything today. Like they're talking, they're like covering one part, that they need to cover. And then he's giving like a ruling. If he can't give a ruling, he's like, yeah, I'll be back in a little bit to give you a ruling. So that's pretty exciting that he's not waiting until the end to do everything, at once. Right? Trips. Yeah. Just like, that's how I feel when, I don't know. After, like when you get older and you find out, if you do have diagnosis and stuff and you accept them, you just embrace them because it's something that you can't change. I feel like you live a happier life, like I'm 39 and I know that like when I look in the mirror, I'm like, I can't, I have to like what I see because we ain't changing it. Do you know what I mean? So like when you can feel comfortable with yourself, it's like a whole new, like, it's a whole new experience of life. When you accept everything like that, you accept yourself for who you are and you're like, I don't need to change anything about myself. It just, I don't know. Life just seems like it goes so much better. It's just easier. And I love that. Yes, nobody's perfect. Absolutely. I definitely can like see the my aging a little bit, but that's fine because like everyone ages. That's what we do. We get older. You go your own route. Me too. So they're just on break. They're taking like a 15-minute break. I don't know how long it's been. Probably like 10 minutes. Oh, Kaylee, I'm sorry. Yes, my mom, Felicia, my mom told me to treat people the way I wanted to be treated, and it stuck. We were never like, me and my brother, we've always been genuinely, and I'm gonna say this about myself. I'm gonna give myself a pat on the back, but we've always genuinely been good people. Like, we won't, if someone's on the side of the road and their, car is broke down, we're gonna pull over. We're gonna help you out. Someone's coming behind you, you open the door for them. Even if they're 20 feet behind you or 50 feet, you hold that door, you wait for them. You wait 5 minutes until they want to come out. That might be an Ohio thing. But just having good manners, just like we're missing that on YouTube right now too. If you guys have been around anything with, Sebastian's case and stuff, you guys will know, like, it's just that's the total shit show. Oh, do you think his mom dead? Kaylee, you're 40? I thought you were in your 20s. I'm going to be 40 this year. Shells, my parents did a good job too. They did. And that's the thing, like, when you get older, that's when you can tell them, like right now, like I'm 39, I should be able to be like, Mom, Dad, you guys did a great job. Like, you know what I mean? Like, and thank them. And it's sad that I don't, I can't have that opportunity to thank them for raising such good kids, especially my brother. My brother is a stand-up freaking dude. He is, I mean, and he is an incredible human. So I was reading your comments. I'll stand and hold the door for a person after person after person. I am like that too. I'm so like that. Yes, I do that too, especially if they're older, especially at Kroger, because when you park in the handicap parking, because I have a handicap parking pass, because of my legs, but sometimes I'll park there, sometimes I won't. But if I do, I always notice at Kroger, the shopping cart return is in the middle of the parking lot. So if you're parked in the front because you need to park in the front because of your disability, you still have to walk your cart all the way through the parking lot. So it's like, why not just park all the way out in the back of the parking lot? So, because there's like 10 or 12 like handicap spots. So I always try to, be kind. And if I see somebody and they have an empty cart, I'll take it over for them and do stuff like that. Oh, Shells, I'm so glad that you have your mama to thank. I know Vincent had to talk to his mom. Well, didn't have to, but he talked to her for a while last night because I don't know if you guys know, but Vincent last night when he was driving home from work, he was going on the on-ramp and his tire, his axle, and his ball joint completely broke. And his wheel was like under his car, pretty much. And so he didn't get hurt. Thank goodness. Thank goodness. Thank goodness. Because I don't care about the stupid car. I care about him. But he's okay. And so we have 0 cars now. We had 2 cars, but one of them we needed to get fixed. We're not sure what's wrong with it. It probably is a simple fix. I don't know why we don't just get it fixed. But then instead of fixing that car, we bought another car. And then that's the car that just, had the incident. It's not like a new car or anything. So it's, I thought it was going to be totaled out, but I guess they're going to look at it tomorrow. Vincent had it totaled to the shop where they fixed the axle just recently for him. And yeah, so they're going to look at it. I hope they don't charge him. I hope they say, hey, this is covered under warranty, or I don't think that's going to happen, but I just don't want him to sink money into a car if it's not going to last. You know what I mean? Like, if something else is going to go wrong in a couple days, like after we get the axle fixed, what if the transmission goes out? Or, you know what I mean? It's an old car. Like, it has a lot of miles on it. So like I told Vincent, I was like, what if we sold one car and fixed the other car? He actually has 3 cars. One of them is in California and it's perfect condition. So he may have to go out and get that car and drive it back. If he does, I'm going to go with him. And that means you guys are going to go with us because it would be like a whole road trip. It would be so much fun. I would love to take the dogs, but they are not good in the car. They're terrible in the car. Oh, yeah, we have a car. We have a car right now for like a month or something like that. It's a Mazda and I guess has like red leather seats in it. I'm excited to see that. I haven't been down there to look at it yet. I heard him talking.
without Dr.
Yeah.
Middleman, therefore making that motion moot, and that they will proceed
Oh,
with
there's Bricka.
using the generic term or the generic evidence of a tip leading to the identification of Mr. Kohberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is how, exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Kohberger by name as the possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Kohberger, that set them on a train or a trail to charging him, was the genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think the thing that led to them investigating him was the investigative genealogy. I don't think that's what led to, the only thing that led to charging him.
I apologize. You're true, right? It was what they led them to investigate him and ultimately charge him. But I think that the court could issue an order or at least require the state to make a proffer exactly how they're going to do this. The reason I'm here is because I've done a lot of cases with DNA evidence. And the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer. And the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. And it's not our job to tell them how to do that, but I think the court has to be vigilant.
Well, I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you want to come up with some instruction to the jury that basically says, you know, we're not going to tell you what that tip is, and you don't need to consider it, or something like that.
Is that an invitation?
It's an invitation for you, two sides, to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments.
I mean, we see this sometimes, not in the context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes then we want, we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I have seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity with the jury and they can get sidetracked. And so we will frequently use an instruction to the effect of, law enforcement's search of the backpack has been found to be lawful, and you should not consider or concern yourself with that. Okay. Right. And so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important, and you're not to do it. And I think that generally causes them to back off that. And so that's what I'm suggesting that you try to work through.
Okay, will do. Thank you. That's all I have to say.
I didn't mean to cut you off. If you have
No, that's all I have to say. That was the only concern that was left for us.
All right, thank you.
Well, not the only concern, because we're still going to be here.
Joe, I think that fairly states where we are. I was curious what the defense meant in their reply where they said that the testimony about the tip should not falsely suggest other evidence, and I still have no idea what that means. But we are happy to engage in discussion about a jury instruction like the court outlined. I will comment that it seems like it took a long time to come full circle because we're right back where the state started a long time ago with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also for the record, there were some pretty serious allegations, ethical allegations made by the defendant in its motion in limine number 11. Those were factually rebutted very clearly in the state's response. And I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
Well, you know, sometimes we litigate issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches and other things, and that's all okay. And I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment right now, at least, as it relates to that. To me, this is a practical problem, regardless of the reasons you are in agreement. The important part is that you are in agreement. I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Kohberger that put him on the radar, right? And so I think that's just where you come. I don't think for those purposes, we're suggesting that the state can't present its evidence about the car, suspected car, about the defendant's whereabouts on the night, et cetera. Those are things that were discovered and put together after the fact, right? I think it is important to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out. And if you can't, we'll revisit how to address it.
Yes, Your Honor, I appreciate that. And the state's intent, we've already spoken with the investigators to develop this, is to have probably Detective Payne, who is one of the leaders and the lead investigators, to simply testify that they received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thank you, sir.
And so we have a pretrial in next month. And so hopefully you can come to an agreement on how this is going to be handled specifically by that time.
Yes, sir. Thank you.
Anything to respond to, Ms. Barlow?
No, nothing on that.
All right, thank you. All right, that leaves in category A by my score sheet, the alternative perpetrator evidence, which is the state's motion in limine.
It's the state's motion. Do you want to sit here? Oh, I didn't see that one. Why do you stick that one in there?
I just forgot it.
Thank you, Your Honor. And this is actually a very convenient transition. We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do
So
that.
for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without making a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on the case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
That's all.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that
That's what
it
you've been doing.
requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think there's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of, at this point, I think we need to flesh that out before we go down that road. And so I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial, since you're here to take care of that.
Thank you, Your Honor.
All right. And I want to be clear, I don't view Meister as controlling. For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of generic, unknown, unsub, to use the part of the craft involved. This relates more to allegations of somebody more specific, identifiable. All right. Let's talk about DNA, which is the inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up the third. I think the first two relate to the kind of the same thing to a degree in terms of the science of statistics and probabilities and all that. There are really three issues, as I understand it. One relates to how to convey the statistics that DNA analysts use to more real world comparisons to, for example, planetary population. The second deals with DNA that was found under one of the victim's fingernails and by the DNA analysts as to whether or not Mr. Kohberger could or could not be excluded. And then the third really deals with more sort of this labeling problem that we've already addressed in some fashion in different contexts of what labels should, can, and must we use as it relates to the quote unquote touch DNA that was found on the knife sheath.
Yeah, yes, thank you. That's a great summary. And I'd like to start with the first point that the court noted, which was motion in limine number 14, which was the relationship of the world population to the statistic generated from the sheath evidence with Q 1.1. And I think we are in agreement that the state is not going to address that kind of question in front of the jury because their own analysts during the grand jury essentially told them that you can't do that given the statistic that we have generated.
I understand the state's response is that they will present the testimony consistent with the way that the witness presented it at grand jury.
Correct, and it was my understanding.
Not in the way in which the question was asked that the witness sort of corrected the attorney about.
Correct, and the objection from the defense was simply, and I think the witness explained this very well, was that the statistical analysis that the state's experts have engaged in does not allow that kind of comparison. It's not the standard statistic that we're used to anymore. And so by asking that question, you're triggering, you're conferring, or not conferring, you're speculating, essentially, put in front of the jury. It's a question that presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the testimony as laid out in the grand jury proceedings.
Okay.
Excuse me. The inconclusive data, I don't know if the court has seen that late, I apologize, all of a sudden my voice is just
Get you some
disappeared.
water.
I don't know if the court has seen the latest filing from the state.
I did see it.
Okay, so they filed a new expert disclosure on Monday from an expert who went through and analyzed the data at issue. So as
Response to the defense's having retained an expert who discussed whether or not you could exclude Mr. Kohberger from the DNA found under the fingernails.
yes. And what triggered that was the grand jury testimony where questions were asked of the analyst regarding the meaning of a conclusive versus an inconclusive data result. And the analyst testified as to 13.1, the fingernail swabs, that their data was inconclusive. And to the defense, and that means that you cannot draw any conclusions. So the defense retained cybergenetics, which uses a different statistical tool than the lab here, and generated a statistic which is strongly exclusionary of Mr. Kohberger from that particular sample. And while that doesn't preclude the evidence from the state lab, it adds additional information to the picture, the overall picture. And
It's just a question for the experts to testify about and the jury to make its conclusion.
well, I think that allowing the type of questions and apparently now the new conclusion that was in the state's response to our motion would be inappropriate and prejudicial and should be excluded under and you have
Do
to.
you want me to believe your expert and not their expert?
No, I'm not asking you to believe any one in particular. However, what I am saying is that the amount of time and energy it will take to explain what inconclusive means is essentially far greater than should be the job of the defense to do. Inconclusive means inconclusive.
Yeah, that's all it means right there. That's all you need. 1 second, 2 seconds.
No, I'm not saying that. I think it can be presented and it can be presented in a fair manner that is consistent with due process and the right of Mr. Kohberger to confront it. The new disclosure from the state is an expert who went through in great detail. We have a 27-page report from him where he not only reanalyzed the data visually, but he also used another statistical tool. And he stated in his conclusionary paragraphs, and it's a very long report, that first he looked at the data using the lab's
he is telling the
protocols
judge to
and doing
believe
some
her.
validation himself, essentially looking at their validation studies. And he found that just
So she is telling them to believe her expert. That's what she's saying. Believe my expert, not theirs.
visual examination of the data excluded Mr. Kohberger. He went a step further and he said, I'm going to use this new third tool called LR Mix Studio to generate the same statistic or similar statistic that the lab did, the state lab did, as well as True Allele Cybergenetics did in their analysis. And he came up with a strongly exclusionary statistic. So we have now before the court, as he describes it in his disclosure, a statistic from the state lab, which means that it's 25 times less likely if the DNA originated. I always have a hard time with these numbers because you have to be extremely careful how you say this because it can flip the meaning. So let me just double check. His statistic, I'm sorry, I'll start with his. It's 5,000 to 100,000 times less probable that a coincidental match
We don't care.
would be made to an unrelated person. In other words, what he's saying is that it's Mr. Kohberger is not included, and that's a strongly exclusionary statistic. And I'm not saying this very well, Your Honor, because it's a tough, these likelihood ratios are hard to explain. So that's a 5,000 to 100,000 times less probable that Mr. Kohberger is present. In other words, it's much more likely someone else is there if there's someone else there. Then the cybergenetics came up with a number that is in the range of 2.8 billion times less probable that he is there than some other unrelated individual. And this expert then relates that even the state lab's number is 25 times less likely that Mr. Kohberger is there than some other unrelated person. So all of the numbers point to exclusion. The numbers, the question is really the weight of it. And the way that the state intends to present it, and they presented it in their reply to our motion, was they should be allowed to say that this means that Mr. Kohberger cannot be excluded. And that is just a misrepresentation of their own data. None of the data that's presented to this court at this moment in this motion supports that statement or that conclusion. And it's unclear to me who is going to say that, because it's not in any of the disclosures that have been produced so far. The first time we've seen it is in this reply brief. So I think that rather than having a battle of the experts, right, where you're going to have all three of these people testifying before the jury, and to allow that just one question is going to subsume an enormous amount of time in explaining why it's not in it, why it's inaccurate. And while it might be technically true, it's not an accurate statement for the jury to consider, and it's just going to confuse them. And it's highly prejudicial to Mr. Kohberger. So we would ask the court to, if it's going to allow this in, and we haven't asked to exclude the evidence, we simply asked the preclusion of this kind of questioning, that the state be precluded from inferring or asking a question to elicit some kind of inclusionary statement. I hate these numbers.
Thank you, Your Honor. So let me just explain a little bit about the state's position. The state has no intention of suggesting to the jury that, oh, maybe this is Mr. Kohberger's DNA. We just don't know. That is not what the state is trying to accomplish. What happened is the Idaho State Police Lab tested this DNA, and they came up with their likelihood ratio. And that number fell within a buffer zone. And under their policy, that buffer zone, generally speaking, with a likelihood ratio, anything less than 1 suggests exclusion, greater than 1 suggests inclusion. But they had done their own internal validation studies and had found that they were getting some false positives and negatives when you're close to that 1. And the range that they came up with was 0.01 up to 100. And so their policy is, if it falls within that range, 0.01 to 100, we report it as inconclusive. Not just meaning you can't, uninformative. You cannot draw one way or the other, whether it's exclusion or inclusion. And so that's what we had from the Idaho State Police when we went to the grand jury. We thought that it was important. What we were trying to portray to the grand jury was that there was the only DNA that connected Mr. Kohberger to the crime scene was on the knife sheath. But the analyst wasn't willing to just make that general statement because there was this issue, this inconclusive.
I understand it's not the state's position that DNA is or likely could be Mr. Kohberger's under the fingernails, that it's unknown people from however the victim lived her life in the hours, days before this event, and whoever was the perpetrator may have been clothed in a way that fingernails didn't contact skin. I assume that's the state's position.
That is exactly correct, Your Honor. The state's theory here is that one would not expect the perpetrator's DNA to be under her fingernails, given the eyewitness account of what the perpetrator was wearing, the complete lack of any defensive wounds on this particular victim, the toxicology report. All of that suggests you wouldn't anticipate this to be the perpetrator. And so we have no...
So does that mean the state's not going to present this evidence in a way that would suggest or argue that it could be Mr. Kohberger's DNA?
Absolutely not, Your Honor. No, and that was part of that rather lengthy, I admit, report that was submitted on Monday was to demonstrate, yeah, when the other issue to keep in mind is the Idaho State Lab uses a different program than the True Allele program that was used by the defense experts. So the Idaho State Lab pointed us to someone else they were aware of that used the True Allele program and said, "Why don't you speak with him?" We spoke with him, and he came back with the same result: exclusion. Nevertheless, given their policy, the ISP analyst is not willing to say he's excluded because their policy prohibits her. But the plan for the state, to the extent it addresses this, is for all of that information specific to her about the policy, and it fell within the policy. And that's why I'm saying that's what the state would present. And of course, she's open to cross-examination. Of course, the defense can put on theirs that can say, no, we can say he's excluded. The state has no plan or intention to in any way ask questions, imply, or certainly argue that this DNA belonged to the defendant. That, again, we will actually be arguing much different than that, that you would not anticipate the perpetrator's DNA to be under the fingernails. And so that's where that is coming from with the inconclusive data. On the issue of the statistical analysis, that we agree. I mean, we're not going to ask that question. The only kind of remaining issue we have is I think their motion specifically asked for an order excluding that question or other questions like it. I'm not a big fan of that language because it's just kind of vague and we're not entirely sure what that means, but we'll stay completely away from the population of the world or a country or a city or anything about population. That's all. Thank you.
I would just like to say, Your Honor, that I guess we're in agreement, and as in an abundance of caution, I might ask the court to issue an order just that if things change, that the state has to come to the court before even trying to present such evidence.
Thank you. It sounds like, and I'm not trying to tell either side how to present their evidence, that the state's not intending to present the fingernail evidence as somehow being inculpatory. I could see, based upon cross-examination, et cetera, the defense questioning the lab person in an attempt to maybe attack the credibility of the lab, which then may require the state to put on its rebuttal expert that it's identified as to that issue. But I think we're at this point safe, based on what you've said, that the state does not have a good faith basis to suggest that the DNA, to make an argument that the DNA could be Mr. Kohberger's, that they not do that without first talking to me outside the presence of the jury based upon what the state of the facts on the ground may be at the time. As to how you question with respect to statistical analysis, I guess as guidance, it seems to me the answer that was given to a question that the analyst kind of rejected is probably the way the state ought to approach it, but I'm not going to tell them exactly how they have to ask the question. What I will say is I will make sure I'm aware of the way that it was asked in a way that was concerning, and certainly if a question is asked in a way that is concerning, the defense can object, and I can respond accordingly. All right. All right. Next motion to eliminate is defense 12 regarding the make and model of the suspect vehicle. Oh, I'm sorry. Did I miss one? Oh, you're right. Within the group I identified before was the touch DNA. I apologize.
Still in DNA.
Yeah.
Your Honor, this is basically a two-part motion. One is to exclude the use of the term touch or terms touch and contact, and the other is to specifically exclude an opinion of Rylene Nolan regarding the sheath DNA and her conclusions as to the how, what I call the how and the sort of when of when the DNA that was determined to be on that sheath, item 1.1. And I'll start with the touch and contact language. Admittedly, that is language that has been used for a number of years in the
Your own expert used it.
Yes, she did. And we would be fine with the court precluding her from using that term. I think what is happened in the world of DNA, having been doing these cases for unfortunately 30 years, is that there's been an evolution. And we laid that out pretty well, I think, in our papers, an evolution of DNA testing, where people started realizing the sensitivity of this methodology allows you to pick up DNA from objects that have no visible stains, like no blood, no saliva, no semen. And that led to the use of the term touch or contact, because the implication and the theory behind it was that people who touch things leave things behind, leave DNA behind. We've now moved into a world where we know that not only can people touch something and leave their DNA behind, but for instance, Mr. Nye was just standing up here. He was touching the podium. I've now placed my hands on the podium. His DNA is probably on my hands. And when I sit down and pick up my phone later, I could transfer his DNA to my phone.
Sure. But
Nobody's gonna-
it probably also include your DNA too. Right?
Of course, but not always. And the problem with the use of those terms is that it essentially allows a conclusion to be presented through a description. And there are many, many, many ways to describe touch or contact DNA. And Ms. Nolan illustrated that in the second disclosure that was produced. And I have copies if the court does not have them. If you would like to review those, I can have them marked. And she goes through her entire discussion of transfer, which is the question here, transfer. How does DNA transfer? And how did it transfer in this case? And she does not use the word touch in describing that process. It's not essential to the description of the process. It's not essential to the explanation of how DNA moves in the environment, because many of the things she's talking about with transfer happen with any biological fluid, not just skin cells. It happens with blood, saliva, etc. So it's essentially allowing the state to prove something, a very important fact in this case, simply by asserting that the term touch DNA is usable or acceptable in the forensic community. We presented at least 3 sources that say, and these are reputable people who are publishing in reputable journals, saying that this type of language is misleading, and it can lead to a misunderstanding of the evidence itself, because touch DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from a person has gotten to an object, whether that's through direct or indirect contact.
I assume your expert's going to tell the jury all that.
I'm sorry?
I assume your expert's going to tell the jury all that.
Yes, and Ms. Nolan will be telling the jury that as well as she testifies.
So what are we worried about?
What we're worried about is that it's confusing to the lay person to hear an expert use a term that is essentially a description of activity. I'm not very good at grammar, but I believe that's an adverb. And it is not one that is useful for a jury, and it will be misleading, because ultimately the experts will be discussing a much broader source of what we might call contact or touch DNA, which is anything that comes from a human being, including saliva or blood. Just because you don't see it, just because you can't see a blood stain, doesn't mean it's not that stain or that area that is sampled doesn't have some other biological fluid. So it's very misleading. And it's just not necessary. And there's a paper that was presented as a human factors report that was published last year, where the the consensus, although there were 2 dissenters, is that analysts should not be using this kind of language and not proffering, and this goes to the next question, not proffering opinions about this, but that the language itself is extremely misleading. There are other ways to talk about it. Ms. Nolan rejects the term trace. That was just one expert's opinion in one article that was cited to the court. But it's very clear she doesn't need to use that term in her description of how DNA moves in the environment. So we would ask the court to prohibit her or any other witness, frankly, from using those terms in describing any DNA sample that's been collected in this case. As far as Ms. Nolan's opinion, again, it goes hand in hand with this idea that touch DNA or the contact DNA is not what it used to be thought of. And there's a number of publications, scientific journals, where the scientists have reviewed vast quantities of scientific literature. I think I counted up over 300 articles in the 2, were reviewed by the 2 articles that were cited in the moving papers that say that there is really no way for a particular analyst in a particular lab to determine how and when DNA was placed on an object when you don't have any facts behind it. In other words, unless you see something or you know something, you have facts of the method of transfer, it's not possible. So first of all, Ms. Nolan is not qualified to offer such an opinion. It's very clear from the growing consensus in the community that transfer in and of itself, how things get places, is a separate expertise, which requires separate training. And a DNA analyst working in a laboratory does not have that kind of training. And in fact, it's not really provided in the United States. There is a paradigm in Europe that is being used, but it's not been accepted or used here in the United States at this point, which is the concern from some of the experts who were on the human factors report. But Ms. Nolan is not at all qualified. If you review her CV, which was part of, I think, the first disclosure in December of last year, going through the list of courses that she's attended, none of them are specific to transfer. And in her affidavit that was supplied to the court, she discusses attending some presentations at a recent meeting where there was discussion of transfer, where some unnamed individuals disagree with this idea that it's not something that should be testified to. But I think there's that her presentation, and this is what the court has to consider, the facts presented by the state in support of their opinion, is not supported by anything other than this vague statement, well, some people don't agree with this position. We don't know who those people are. The state and Ms. Nolan have presented no particular scientific articles that support her opinion. And she has presented no specific training to take her from an expert around DNA testing, which no one is suggesting she is not, to an expert on the how and the when of transfer in this particular case. Then when you look at her opinion, I think the court has to exclude it because it's highly speculative and it's incredibly confusing. She first states that the consensus in the community is that you cannot determine when and how DNA moves onto a particular object. She says that without any qualifications, that the science doesn't support that. She then proceeds to say the DNA on the sheath could have gotten there through indirect transfer, meaning it was not placed there by direct contact of a hand, for instance, with the object. And then she goes on to say, but because of 2 facts, the quantity and the fact there's a single source, I believe it got there through direct contact. She offers this court absolutely no information to support that. She doesn't.
Other than those 2 things.
I'm sorry?
Other than those 2 things.
Well, yes, those are 2 facts, but those facts and the meaning of the facts are relevant. We cited a number of cases that talk about expert witnesses and speculative opinions. And our position is that this opinion is so speculative and so confusing that it shouldn't be presented to the jury, in great part because Ms. Nolan does not present this court with anything to support her conclusion. She's basically saying the science says I can't do this, but I think I can. If that we were in a different place where we had some articles to support her conclusion, if there were articles to support the fact that the amount of DNA or the fact that it's a single source sample is probative of that the scientific principles and methods of DNA testing support that, then we'd be in a different place. But that's not where we are. We're here with a naked opinion with no foundational facts to support it, other than Miss Nolan's training and experience. And while training and experience is a relevant consideration for this court, we don't even know what training and what experience she's relying on. We don't have any indication that the lab has done any studies internally about this question. We don't know what literature she's been reading. And frankly, even though she attended this meeting that was held in February, where the proceedings are online and available, she didn't bother to let the court know who spoke and what they said. So I think the reason is because she doesn't have any support for this. And it's going to be incredibly time-consuming, not only to cross-examine her, but to present evidence to rebut her opinion. And given the speculative nature and the sort of both sides of it nature, I think the court has to exclude it.
Thank you, Your Honor. I'll start where she left off. I don't think she's accurately characterizing what the opinion that's been disclosed. Ms. Nolan did not say, I agree that the science says you should not opine on this or that you cannot opine on this. All she says is that the science does say you can't conclusively establish it. But there are factors, she lays out a lot of those factors that you can look at to decide, to indicate how it ended up there. And she's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, it was primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations and she's giving her opinion, which is going to assist the jury in reaching their conclusion, because the jury's not familiar with any of these factors that she's laying out for them. So, and then as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for 2 decades. She's a forensic scientist. She specializes in biology and DNA. For the last 10 years, she's been the lab manager and overseeing all of the biology and DNA. That includes instructing, as indicated in her CV, law enforcement and others on the collection of DNA. What we're discussing is a critical component of all of that, which is how does DNA get from one place to another? She has plenty of experience to talk about that while admitting that she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say to a scientific certainty that this is in fact the case. Now, on the issue of the touch DNA and just the label itself, I don't know that I've ever litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. And she didn't just use it, she used it specifically in reference to the DNA on the knife sheath, the exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case use that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury. Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that. I don't think it's outside the bounds or intellectual capacity of a juror to understand that sometimes in particular professional fields, there are phrases used that may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it. Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert, but their own expert, they're admitting that there's something there to be cross-examined. And so if this court orders there can be no statement or no mention of touch DNA, then I think that cuts off a very legitimate line of cross-examination from the state.
So I'm not particularly fond in general of proscribing phrases and words that can be used by parties and witnesses in cases. I think it just creates the potential that you're going to have problems because people slip, and particularly when you're using phrases and words that are commonly used within the field, right? We see that all the time with the use of the term victim, right, in cases, and the Supreme Court has recently weighed in on that issue. There's actually an ICHE instruction that deals with the use of the term victim because it's just, it's hard to police phraseology. On the other hand, if what we're talking about is an agreement that, this term may be implying something that we all agreed isn't necessarily true in all cases, I mean, we could call it blueberry DNA for all that matters, right? And your experts are going to explain what it means otherwise. What's the concern here if we say, let's try not to call it this? Other than accidental violation and now somebody's asking for a mistrial, right? I mean, that's one of my concerns.
So in reality, that's really the state's only concern is we don't want to get in a situation where there's a word that's off limit, and because she uses it, the defense expert uses it, it slips out at one point that suddenly we have a motion for a mistrial because there was a violation of this court's order. As defense counsel mentioned, Ms. Nolan didn't rely on this word heavily much at all in her opinion, and I don't anticipate her testimony to be anything different. But if at one point in the back and forth, either with us or with the defense attorney, she slips and says the touch DNA on the knife sheath, I don't think that that's a problem. And I don't think that it's something that this court should restrict. I think both of these experts felt comfortable and wanted to use that phrase. That's why they used it. I don't think it's superfluous. I don't think they just said touch to say touch. I think to them it means something, and it's accurate to use it in this case with respect to the sheath. But certainly the state has no problem encouraging Ms. Nolan to avoid that word to the extent it's possible.
Thank you.
Thanks, Your Honor.
Just a quick response. Language is important, and language in science evolves and changes. Ms. Nolan and Dr. Ballard, our expert, are scientists. They present themselves as experts. And I think that scientists should be held to a slightly different standard than the average witness. And the use of language, as this court pointed out to me early on when I first stood up here, is really, really important. And I am confident that Ms. Nolan can restrain herself from using that language. And I'm confident that all of the parties can ask questions that do not elicit that kind of information or use those words. And I would encourage the court to restrict the use of those words for this proceeding. As far as Ms. Nolan's opinion, no one is asking for certainty. Nobody expects scientific certainty. That is not our position. The question is it supported by the science that Ms. Nolan is essentially testifying about? And the answer to that is no. Her personal opinion is not science. It is a personal opinion. And if the
You're relying on a scientific report to which there were dissenters.
Yes, but the dissent was not about the content of the recommendation. The dissent was we don't have any options, and maybe we shouldn't be requiring trainings that are not particularly available in the United States. That is the nature of the dissent. And
But in support of the idea that this testimony shouldn't be included by these people.
I'm sorry, I couldn't.
But in support of the dissent, in support of
Yes.
opposition to a scientific consensus that this testimony should not be presented.
That's correct, but I don't think that the court has to rely on a 100% consensus of the community. I think that the evolving understanding of the science and the scientists in this area and of the people who are actually publishing work is highly relevant to whether or not that kind of opinion is actually acceptable anymore. And I suppose that the question of admissibility might revolve around a more like a Daubert standard. But given that we have not had the opportunity to see these opinions until so recently, that was not something we were able to do.
Yeah, the Supreme Court has specifically rejected the Dover standard.
Well, I'm new to Idaho laws, Your Honor. That's why I suggest Daubert. But that kind of analysis, I think, is the same type of analysis that this court has to do, as sort of essentially a gatekeeper to make sure the jury is hearing reliable evidence. And I think that if you read closely, in particular, Ms. Nolan's second disclosure, which I believe came out in February, or was given to the court in February, she lays out a whole series of things that affect transfer. She makes one statement about the quantity of DNA being higher with direct transfer, but that's not elucidated in any way, and doesn't talk in anywhere in that disclosure or any other disclosure why a single source profile would support her contention. And I think because of the complex nature of this, that we can't speculate as to why. It may make logical sense, but I'm not sure it makes scientific sense to speculate, which I think is what we are prone to do. And as I think the Idaho courts have said, the court's not supposed to substitute its judgment when for the expert's opinion, but to consider it in the context in which it's presented. And here, there is nothing to support her opinion, absent her assertion of training and experience. I'll stop with that.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA. As to the use of the term touch DNA, I'm not going to preclude it. As I indicated, I think it's a discretionary matter. Science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as the term victim, there's an instruction for. I'm not opposed to giving an instruction to the jury should that term come out. That the court is not intending to, by use of that term or by any of the attorneys' use of that term, making a conclusion. On the other hand, I do encourage the parties to not use the term as much as they can. I think we underestimate the intelligence and reasonableness of jurors, having presided over, I don't know, well over 100 jury trials. I think that we worry about things that they are more than competent to understand and not jump to a conclusion simply by the use of a word, particularly where there's scientific testimony around explaining what that word means in context. And so I'm not particularly worried about it. I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a council, at least try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage council to try to avoid it as much as possible. All right, now I think we're on the make and model of the suspect vehicle.
Your Honor, this is a motion where the words do matter. We're following up on that one. This seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number 1. That invades the province of the jury to make that determination. The state has Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Immel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number 1. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number 1 has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle 1 to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Imel. It is his opinion that the suspect vehicle captured on various surveillance video shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video, while some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance and footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information with other testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014, 2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
And our request is not at this stage to limit Agent Immel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle in all of these clips. Agent Immel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips, that
No.
his expertise.
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
Not actually true, as I understand it. It was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Frank's motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are in the email. It was originally, let's look at this date range. And then he said, well, I'm more comfortable with an expanded, or we need to expand the range through 2015. And that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1. And so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it? Good.
Yes, it was my motion.
Yeah. Sidetrack there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle one is making a specific conclusion. It's again using a term that is used within the investigation, but specifically making an argument that the various vehicles or the various images of vehicles on the various surveillance cameras is the same vehicle. Making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be right. As to the agent's ability to make that conclusion, I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes, and then we will come back. We'll shortly before 1, but no later than 1.
All rise.
Okay, so they said that they're going to go on lunch for like an hour. So what I'm going to do is I'm just going to make like a part 2 to the video. That way, if you guys want to stretch a little bit, get something to drink, get something to eat, all the things, you'll have a couple minutes to do it. And then I will come back on because that was a lot. And so I want to review it a little bit and then go back over everything because they're going through stuff so fast. It's insane. It's crazy. So, yeah, what I'll do is I'll make a part 2. So this will be like the same thumbnail. It'll just say part 2 on it. And I'll make it for, what did he say, an hour? So I'll make it for 3 o'clock my time. And I'll probably come on a couple minutes before that. I know, DM. It's so crazy. Yeah, go have some dinner, Debbie. And I have my headphones in so I could hear a lot better too. So yeah, the defense is burying their own self. It's insanity. They're not doing so hot. But I will be back on. I'm going to make the thumbnail now and the live so you guys will see it pop up. And I will be back in about an hour. So I will see you guys soon. Bye, guys.
Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out. We got this far, don't know how. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we're gonna let it away. Tonight, we're gonna let it away. Tonight, we're gonna let it away. Just like the sunrise, we're gonna let it away. Now just like